This video contains excerpts from an online workshop that the US-Asia Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by US-Asia Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
Yes, and in fact, to go back to what I said, it's a great question, and to go back to what I said at the very beginning, these trials are very dynamic with the way that we treat the admissibility of evidence. But that said, and consistent with at least my personality, which is to control what happens in court, you can, as a lawyer, file a motion or bring it up orally before the trial starts, that you think that a particular piece of evidence, or you suspect that a portion of a witness's testimony may be problematic, may be overly prejudicial, and you would like the court to rule on it in advance. And that way you know with some greater certainty that, you know, that particular piece of evidence or that particular portion of testimony is not going to come in. Can I give a quick example? Oftentimes, I'm a criminal defense lawyer. Oftentimes, the prosecution will want to admit a series of photographs, often of the crime scene. I'm thinking of a homicide case. A number of those crime scene photos can be gruesome. They can be unpleasant to look at. The question then becomes, how many of those photos does the prosecution really need to demonstrate that there was a homicide? They probably don't need all 40 of them. Probably need 10. And of those 10, 3 of them, I think, are so bad, so gruesome, so horrifying that I would argue that those 3 would be violative of Rule 403 and should be kept out. And the judge would make a ruling on that, and then I would know. I might win, I might lose, but I would know what the evidence was going to be before the photographs were admitted into the trial.
It's great. And I would say another common example is if a witness or the defendant has a criminal record, the lawyers would want to know in advance, are they allowed to question the witness about the criminal record? It might affect whether they decide to call the witness or not. So, the character evidence that Tucker talked about being admissible or not admissible, you want to get as many of those questions resolved before the trial as possible. In the pretrial conference, you can certainly do what Tucker just suggested, ask the parties, what's in dispute and what's not in dispute. To make that process meaningful, the prosecutor has to make the evidence available to the defense attorney in advance and to give them a sufficient opportunity to understand that evidence so they know whether or not to agree to it. So in that case, you could save time. If there's no dispute that this hat was found at the scene of the robbery, there can be a stipulation, which is just a fancy word for an agreement, that this is the hat that was found at the scene. It may or may not be, it depends on the defense in this case. If the defense is the defendant was not present at the robbery, he might want to, challenge the hat. But if the defense is, yes, I was at the bank, but I'm not the bank robber, they somehow could make that defense, then the hat's not that important anymore. So you could agree to it. In many narcotics cases, there's no dispute. The defense is usually not, it wasn't narcotics. It's usually, I didn't know there was narcotics. But I will say in our system, the defendant has an absolute right to insist that the prosecutor prove everything. And the defendant can just say, I plead not guilty, and I want the prosecutor to bring all the evidence here and prove it. And I will say this, let's say the police lose some of the evidence. Let's say they're sloppy and they don't do a good job of keeping the evidence secure. Well, in a drug case,
this video
without the drugs,
excerpts
the
from an
defendant
online workshop that the
will be
USALI
acquitted,
Law Institute
or
held
the case might be
in June
dismissed.
2020. The workshop participants were legal professionals or scholars from mainland China,
the
Taiwan,
physical evidence
and
is
Japan,
important, but
who
you
were
can
already
shorten
broadly
the
familiar with
trial,
the United States
and you
criminal
can use
procedure
various
and evidence
ways.
rules. The
If you
presenters
have
were
witnesses
experienced
testify, which are
judges,
the
defense
witnesses that
counsel,
really need to
former
testify?
prosecutors, and law professors.
And that's, I think, a
The
hard
workshops
question
were
for us
designed
to
and led
answer
by US Asia
in
Law
the
Institute
abstract.
senior research scholar Ira Belkin,
In a specific
a former
case,
federal prosecutor.
it would be the questions that are in dispute where the witnesses have to testify. That's something that the defense lawyer, in consultation with their client, after seeing the evidence of the prosecution, can make a judgment about. But it's very hard to make a blanket rule and say this category of evidence witnesses must testify and this other category of witnesses doesn't have to testify. There are some rules because in trials there are recurring situations that come up over and over again. And so the rules anticipate certain common fact patterns. So, for example, it's common in criminal trials that some witnesses will have a criminal record. So we have specific rules about when is that relevant. If the criminal conviction was 20 years ago, well, that may not be relevant to whether this witness is credible. If the conviction was for a very minor crime, like maybe shoplifting, it might not be relevant. But if it was a recent conviction last year for perjury, for giving a false testimony, well, that would be very relevant to whether you could believe the witness. So in the federal rules of evidence, there's an attempt to help the judge by clarifying in certain situations what is relevant and when does the unfair prejudice outweigh the probative value. This balance depends on what the other evidence is. In the bank robbery case, the defendant committed many bank robberies before and was even convicted, but the fact that he committed other bank robberies doesn't mean that he committed this bank robbery, and he's still entitled to a presumption of innocence. On the other hand, if he committed the bank robberies using a very unique methodology, maybe he always wore a particular kind of mask that's very hard to find, and that he always said the exact same words or used kind of a note that was very unique. Well, you might be able to use that prior evidence of prior bad acts, to show that the defendant acted consistently. And it's a way of identifying this person that no other bank robber would likely use that kind of methodology. That would be dangerous because the jury might decide, well, he's committed other bank robberies, so let's just convict him of this one too. So you'd have to be very careful. If you change some of the facts, then you change the analysis of probative value versus unfair prejudice. And you change the balancing test about admissibility. So I think you can have some rules that are helpful for judges, but you have to be careful. You don't want to tie the judge's hands and force them to make a choice that may not be the right one under all the circumstances. So these rules of evidence do give judges a lot of discretion and rely a lot on the ability of the judge to make appropriate judgments.
Ira makes a good point. There are rules which about the admissibility relative to unfair prejudice, and those rules do provide a structure, but there are circumstances where rule doesn't really apply, and where, to your question, a kind of judge's common sense would determine its admissibility. In the example, I have a quick example. I one time had a murder case. My client was male. The victim was female. When the police showed up, one of the police officers, who was a female, was taking photographs of my client. My client had blood on his clothes. And during the course of taking some photographs, my client made a wildly offensive, sexually charged comment to the female police officer. It was horrible. It was any right-thinking person would have been deeply offended. I, consistent with the earlier question, moved before trial started to keep that comment out. It wasn't, my argument was, whatever relevance it may have had to whether my client committed the homicide or not, which, by the way, I argued was very low. All this happened long after the alleged homicide. The fact that my client would have said that thing, which was so offensive, was just going to prejudice the jury against my client. That was not the question that they should have been deciding. Put differently, I would agree that my client acted like a jerk, may have been a jerk, but just because you're a jerk doesn't mean that you committed the murder. And so this judge, by the way, who was no friend to me or my client, agreed with me and used her common sense. There was no particular rule that kept that out.
So I don't have any empirical research, and my guess is that a lot of prosecutors feel that judges exclude that evidence too much, and a lot of defense attorneys feel they don't exclude it enough.
As we've said, the default position is that evidence comes in. Sure, evidence is often prejudicial. I mean, that's why it's relevant, and it's otherwise admissible. So my experience has been that judges do not very frequently preclude evidence under just a general 403 weighing test. And unfortunately, I find more often than not that lawyers really don't have a really solid working knowledge of the rules. And that raises this issue, is the point I want to make. A little knowledge is a dangerous thing. And one of the things I see happening with the rule-based system like we have is those folks in positions of power, whether they're judges or lawyers, can use, sometimes consciously, sometimes not, these rules the wrong way. And it leads to problems, either an unjust result or a process that just is not right because the rules of evidence are not being used correctly. So I guess my sort of point is, as you all are thinking about this, that you also think, I will say that our rules, to me, make sense, especially once you look at them all in a continuum. They make sense and you understand them. But I do think that we all ought to also be aware that to the extent that they're complicated, to the extent that they're not well taught, they can, on occasion, become impediments to, rather than something that is supposed to be helpful to, a just conclusion.
I'm not going to disagree with Tucker, but one of his areas of practice is wrongful convictions, and seeing a lot of cases where innocent people have been mistakenly convicted. And so he's got a ton of experience seeing how even when the rules are applied, they led to mistaken outcomes. I think the basic concepts are valid. I think the requiring people to testify based on personal knowledge is really important. I think authenticating evidence is critical. Our, I would say, flexible approach to admissibility really depends on people exercising good judgment. Sometimes a judge can let evidence in for a specific purpose, but then give the jury an instruction and say, I'm only allowing this evidence in for you to determine X, Y, Z. In the example of the bank robber and the prior conviction case, I'm only letting this evidence in to the extent that you think this method of bank robbery is so unique that it helps you decide the question of whether or not this defendant, it identifies this defendant as the perpetrator. But you are not to determine that he's guilty simply because he may have committed other bank robberies. That would be a difficult instruction for anybody to follow. So I'm not sure that's a great example, but I just want to point out there are sometimes compromised positions that judges can take on these questions.